All set. The first petition before the board is number 895, Flanagan JBC Revocable Trust, Fair Acres Avenue. The proceedings are being transcribed to provide full and accurate minutes and allow the board members to all participate. Will the hearing come to order at 7 o'clock on this 12th day of March, 2014. The participating board members on this evening will be on my left, Vice Chairman Carl Verana, on my right, Clerk of the Board Roy Latimer. My name is Newton, I'm Chairman of the Board. Will the clerk read the petition of the relevant matters, please?
Public meeting notice. The Raynham Board of Appeals will hold a meeting on Wednesday, March 12th, 2014, 7 p.m. at the Raynham Veterans Memorial Hall, 558 South Main Street, to consider petition number, I'm sorry, this is the other one.
No, we're doing that one first.
Oh, we are doing this one?
Yeah, it's Indian.
Okay.
Two instead of one.
Huh?
We're doing two instead of one.
That's right, you're right.
Okay, number 895, Michael J. Flanagan, Joan B. Flanagan, Bryant P. Ferris, Elaine J. McDonough, trustees of JBC Revocable Trust. Request for a special permit pursuant to Raynham zoning bylaws, section 7.4, specific uses allowed by special permit, to allow conversion of an existing one-family dwelling into two-family dwelling with the addition of an in-law apartment at 4 Fair Acres Avenue, Assessors Map 3, Lot 87, Raynham, Mass. Anyone wishing to be heard this matter should attend the hearing. A copy of the plan and the application may be viewed in full at the Raynham Town Clerk's office during scheduled business hours. It was published in the Taunton Daily Gazette February 25th and March 1st, and it's been attested by William Lewis of the...
Thank you very much. All those who intend to give testimony, if you're going to say anything at all, please rise and raise your right hands. Of all you people, no one's going to give testimony in this matter except you and the building inspector. Do you solemnly swear that the testimony you're about to give this board shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Will the petitioner come forward and present reasons for granting the petition?
Good evening. My name is Jeff Proudler. I'm with Sandcastle Homes, project manager for them. I'm here on behalf of Michael Flanagan, his wife Joanne, and Barbara Casassa. We're petitioning tonight for a dwelling conversion for an in-law apartment at their existing single-family home. We're proposing an in-law addition. If you actually would refer to the site plan, we're proposing an in-law addition off the rear of the home. This addition is 710 square feet, which puts us within the guidelines for an in-law addition. We'll still be meeting the setbacks for the addition, the side setbacks and the rear setbacks. The lot, we're before you because the lot has a non-conforming dimension, which is the lot area and the frontage, which are not affected by this addition. The actual addition you can see by the renderings. The renderings are they're in harmony with the rest of the house and the surrounding neighborhood. And the driveway leading up to it is large enough and ample enough to handle any additional parking for an in-law.
Ryan, is there anything else you would want to say on your behalf or the behalf of the people you represent?
I think if you unless you had any questions on any specifics on the plan.
We will be getting into that.
Okay.
Are there any others favorable to the petition? You are Thank you.
Oh, sure, okay. These are actually.
I've looked at these plans that are being presented this evening to the board. I've gone over them, and the structure as it's set up on the property is a good layout that I always like to see when the dwelling doesn't reflect duplex, which I don't like to see in a residential area. And the way they've designed it, it's to the back of the building, which abuts the garage, and the garage in this case being attached to the main dwelling is considered part of the dwelling. And the entrance to this comes in from the top into a area that is like a playroom, living room, whatever, to the main dwelling, and then we have the egress going out of the main entrance, or the in-law apartment, and the in-law apartment itself being on this Fair Acres Avenue, which is an old town road, is off the way, and so it is a very good layout for this type of a situation for the in-laws to be able to move in.
Dead-end road, isn't it?
And it's a dead-end road, and so I would suggest that the board, vote favorably for this
Thank you for your other input.
petition.
Thank you. Are there any others here who would be favorable to the petition? Board members may ask questions of the petitioner. Do you have any questions?
I'm a little curious. Do you have any renderings that have some dimensions on them or something?
Yes, I do.
Or what the layout is of the apartment? I don't have any big problems with it, but
I do.
there's really not much by way of information on this at all.
Sure. These will be the first and second floor.
Oh, thank you, Robert. I was wondering where mine were, and I left them home.
Thanks.
First and second.
Oh, that's much better.
Yeah, that would have been better had they submitted
Yes.
those with the application.
Right. I have nothing further.
I have that, and I'm going
You don't
to,
want anything? There's a copy. That's it. The next two pages are also.
yeah.
Did you get a floor plan of the apartment?
No,
Yeah, there are two pages.
there's one here.
Yeah, but there's no floor plan of the in-law apartment.
Is there a floor plan there?
Oh, do you know what apartment this whole? Oh, no,
Do you have a floor plan?
This whole thing's a floor plan.
No.
Well,
Okay, so, yes, this will be the,
Where, this whole thing?
correct, yeah.
Okay, so it's six,
make this an inclusion with the application.
Yes.
and where's the tie-in to the house? Now, where do you tie this into the existing house with a passageway or anything?
Right where the stairway goes up, we'll come across, so when you come up the stairs, you'll actually be making a left. And if you look on the second page, it shows you that you come up that stairway and make a left, and that's where you're going right into that family room area.
It would have, as our chairman said, been much helpful to us if we had had these plans to begin with. And now we can at least see what you're proposing. And these are, who are the people moving in here again?
Flanagan's.
I own the house, my wife and I, my name is Michael Flanagan, and this is my wife's mother, and she's gonna be moving in.
Okay.
Looks like a Flanagan, doesn't he, huh?
Yep. But these should, as you said, these should be made part of the,
I
Yeah.
asked,
They will be.
will you vote that?
Yes.
They'll be included,
Yes.
vote also. They'll be made part of the application. Do you have any further?
No.
I don't either. Looks pretty well laid out. Any communications favoring the petition?
Did not see any, but I'll double check. One that even- No.
Are there any objectors present? Communications requesting denial.
No.
None. I declare the hearing closed. The board will now go into executive session. All may remain while the board deliberates, but none may speak.
I don't have any problem with this, I think it blends in nicely, it's unobtrusive, it comes within the parameters of the new apartment that we have, so with the usual conditions, it's fine.
I would agree with, it's not even visible from the street.
I agree with it, and with all the requirements of an in-law department be included in this favorable application. Open the meeting, unanimously, the board has decided to grant this variance, and it will be recorded with the town clerk within 10 days and probably within 20 days. It need to be recorded in the Northern Bristol District Registry of Deeds. I thank you for coming.
Thank you for your time.
Good luck.
Thank you.
I never knew that street existed in Raynham. Now, why did the sole site plan say trailer park? Was there a trailer park in there at one time, or near there?
It's across the street from the ice rink, next to the trailer park on Broadway.
Okay, so that trailer park wasn't, okay.
We granted a variance there about 20 years ago, didn't we?
It's been there, I mean, I've lived there almost 25 years, and the people across the street have been there over 50.
Yeah. One of them got a variance a long time ago.
That's what found me up.
Okay. Can you pass that along to the little girl on my right?
Yeah, but it's actually a gift.
Okay. The next petition to come before the board is the petition number 894, the estate of Robert Kirker, South Street East.
This is attested by. There's no attesting on that one, right? This is attested.
No, it is. It's right here.
Do I
I
have-
like these, I just gotta remember.
Did I give you my sheet? Thank you.
Should have attested this one.
I announce the proceedings are being transcribed to provide full and accurate minutes and to allow full participation of all members present. Will the hearing come to order at 15 minutes after 7 o'clock on this 12th day of March 2014, Municipal Building, Town of Raynham. Again, the participating board members will be on my left, Vice Chairman of the Board, Carl Verana. On my right, Mr. Roy Latimer. Who's clerk of the board? My name is Newton. I'm chairman of the board. The clerk read the petition and other relevant matters, please.
Public meeting notice. The Raynham Board of Appeals will hold a public hearing on Wednesday, March 12th, 2014, 7 p.m. at the Raynham Veterans Memorial Town Hall, 558 South Main Street, to consider petition number 894, Thomas P. Crotty, New Bedford, Mass., as personal representative for the estate of Robert Kirker. Appeal seeking the reversal of a zoning determination from the building commissioner that the property on the assessors map 17, lot 127B, 127, South Street East, Raynham, Mass., is not a building lot and is deemed valid by variance granted on October 4, 2001. Anyone wishing to be heard on this matter should attend the hearing. A copy of the plan and application may be viewed in full at the Raynham Town Clerk's office during scheduled business hours, and it was published in the Taunton Daily Gazette February 25th and March 4th, and it was attested by Gordon Luciano.
Thank you very much. All those who intend to give testimony, please rise. Please raise your right hands. You solemnly swear that the testimony you're about to give this board shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. The petitioner or representative come forward and present reasons for granting this petition.
Good evening. Somebody left some plans here. My name is Thomas Crotty. I'm the person who had been appointed as personal representative for the Kirker estate. I think I'm probably the only person in this room who didn't know Robert Kirker or don't know of him. But I was appointed by the court as an independent personal representative. One of the properties that he owned that you might be familiar with is the property at what is, I think, sometimes called 0 South Street East, but it's the lot that's number 127 that's in question here. And in 2001, this board granted a variance for a lot that was approximately 3.79 acres in size, so well in excess of the size to have two buildable lots in terms of area, but it was shy of frontage by, let's see if my memory serves me, by 15 feet, shy of having enough frontage for two lots. So this board granted a variance for that property to be divided into two lots. Within the year, Mr. Kirker recorded the variance, sold one of the lots, the smaller lot, and that smaller lot was built on by the new owners. All that happened within the year. That was in 2001 and 2002 that when the house was finally built. Mr. Kirker then did not do anything with the larger lot for the next 10 years. He passed away in 2012. As part of the handling of the estate, I had a realtor looking into putting that lot on the market, and one of the things he did was talk to Mr. Machado, and Mr. Machado gave the opinion, which you have a copy of his written letter, indicating that in his opinion, because that lot had not been sold or built on within the year of the variance being granted, that the variance with regard to that lot was now voided, and the only thing that you could do with it would be to merge it with an adjoining lot that Mr. Kirker at one point had an interest in, although it's actually held by the All-Star Trust, of which he had at most a half interest in for most of those years, so it's really not owned in jointly, in common by the same people. But nevertheless, I think really this comes down to what I think is purely a question of law, because there have been a few cases before the state Supreme Court in which variances have been granted to take a large lot, divide it in two, and one of those lots has been sold off. And what the state Supreme Court has said is that you have to act, obviously under the statute, you have to act within a year on your variance. In those kind of cases, when the variance divides a lot into two sections, as long as you sell off one of the lots and retain the other lot, the variance stands, and the variance is still good as to both lots. It doesn't stay good as to one lot and fail as to the other lot. it's still good, because otherwise what you've done is you've retained a buildable lot, but because you didn't build on it within the year, it's no longer buildable. And now you can't do anything with it, because if you had not gotten the variance and just gone ahead with it, you could have done something else. So the state Supreme Court has said, as long as you sell one off, that's fine. In fact, what the state Supreme Court has said is you either sell one of the lots off or build on one of the lots, and that's reliance on the variance, and that's good. They said or. Actually, in Mr. Kirker's case, both happened. One lot was sold and it was built on. So we have a case where, I think, a situation where under the case law, this clearly is still a good variance, and clearly this should still be a buildable lot. My suggestion would be that maybe if you need to, because it is purely it's not really a discretionary call, it's purely a question of law, that if you need to run it by town council, that might be a good idea. But in any event, I think the law is clear anyway, that this lot is still good, the variance is still good, and the lot's still buildable.
Are there any others who would be favorable to the petition? Attorney Varana, do you have any questions?
I don't.
The only question I have, when did that trailer is on this lot 127, isn't it? The house trailer?
There's a house trailer, a mobile home, whatever,
Yes.
on an adjoining lot.
That's on the adjoining lot,
Yeah.
okay.
And that lot actually, that's the lot that's in the All-Star Trust, and as I read it on the maps, that lot has 120 feet of frontage.
Okay,
So that has even less frontage than the lot that got the variance.
okay.
Can you explain to me the findings of Baldiga versus Board of Appeals of Uxbridge?
Is that one of the cases that's listed here?
Yeah.
I don't see that here. I'm not familiar with that.
You want me to give you a copy?
Sure.
Yes, for it.
Oh, that's on the, that I believe is on the issue of whether the two lots side by side are held in common ownership.
Mhm.
Yeah, that's not really that's not really an issue here. The issue here is, because when the variance was granted in 2001, the small lot that the mobile home is on,
So,
that was owned by the All-Star Trust back then. So the variance was granted in 2001, and what you had was one big lot, one super lot, owned by Robert Kirker personally, and then you had one small lot held by the All-Star Trust. Whether or not those would be considered common ownership, that's the way it was in 2001 when the variance was granted. And that, except for Mr. Kirker's passing, hasn't really changed. That small lot is still owned by the All-Star Trust. His daughter now owns the shares in the All-Star Trust, either half the shares or maybe all the shares, well, 999 out of 1,000 shares. The large lot is the one the variance was granted on. So even though there was an adjoining lot that he may have owned or may have some control of in 2001, the large lot still was given a variance by this board. So that, nobody's asking that be revisited or that be undone or repealed. So in effect, that variance was granted. It was, no appeal was taken from it. It was recorded, so it became a valid variance. And then within the year, now that variance cuts that in two, he sold off one of the lots it was built on, leaving the middle lot. So I understand what you're asking about is the issue of common ownership. But that doesn't come into play in this case, because if the variance is good under the law, we don't even get to the issue of common ownership. That's something that would only apply if the variance was not good in the first place. So our position is that the variance is good in the first place because he acted on it. So we don't even talk about common ownership. I'm not here to address the issue of common ownership. I haven't looked into a lot of research on that. At this point now, the estate owns the one remaining lot, a separate trust, and obviously he's not involved in that anymore because he's deceased. A separate trust, which we can't control at all, now owns that adjoining lot.
All right. Thank you. Thank you. Are there others here who would be favorable to the petition? Questions?
So were there any other questions? I sat down, but
Please?
any questions?
We're asking that now.
Okay.
Do you have any questions? I don't. Communications favoring the petition?
No.
None? Any denying the
No.
petition? It appears there may be objectors present. Will they come forward and present their reasons for objecting?
There's no question here this evening that the Board of Appeals granted a variance for the two lots. And that's really not the issue that they were granted. The issue here is the way that these properties have been held in ownership. We look at it, and it's been through all the records showing as a trust. And the trust is and was Robert Kirker and the Kirkers in general, and is still that way today. It is still owned by the Kirkers. And since it has been an ownership that is, it's not related to, it's not a common ownership, but it's all controlled by that same family. And one of the family members owns approximately 60% of it. And therefore, whatever they want to do with that property can be done. So when you look at it, and this property here, I don't know if you can see it, but I colored it so it'd be easier to see.
Mm-hmm.
I should have made other copies of it. But you can see that the pink lot is lot 127A that was part of the variance granted by the Zoning Board of Appeals. That lot was sold off. And the yellow lots were the two lots that were still owned in the trust in Robert Kirker, which is all in one and the same. Now, you take these two lots and they're together. They border each other. And when you have lots that are bordering each other and they've been in ownership for approximately 10 years or more, if you read the law, it says that if they're joined together, if they're together bordering each other, those lots have got to be joined together for the purpose of zoning. Doesn't mean to say you have to make it all one lot, but for the purposes of zoning, if you wanted to use one lot, lot 127B, then it has to be joined with 359 South Street East. And the reason for it is because lot 359 has approximately, I'm going to say 23,000 square feet with 120 feet of frontage. Lot 127B has only 133.5 feet of frontage. Although lot B, 127B, has a lot of acreage, that's not the issue. The issue is these lots were together and they were all held in the ownership. That ownership can do anything they want to, and as long as those two lots, they border each other, then they have to be joined together for the purposes of zoning. Now, another scenario that was brought up when a variance is granted and one lot is sold off, then the variance is exercised. I agree with that. I don't agree with this one because Lot 127A was sold off, leaving 127B with a lot that was owned by the trust and Robert Kirker. It's all one and the same. Now, if they had sold off 127B, then 127A would not have had any land, butting it in order to be joined for the purpose of zoning. Therefore, that would have been a legal lot, and the right of the variance would have been exercised. But as it is now, that's not the case. 127B is very clear, is with the 359 South Street East, and therefore must be joined for the purpose of zoning.
Thank you. Thank you, Mr. Machado. Do you have any questions of Mr. Machado?
I do. Are you saying that the 127, getting some signals from the back. Are you saying that lot 127 and the other lot, the smaller lot that you referred to, are owned by the same entity?
Yes,
And what is that entity?
it's the trust and Robert Kirker, and they were all in the same, through the Kirker family. It's all the same people that own all those properties. And you will hear testimony of that this evening.
Okay, but I guess what I'm trying to understand is, are you saying that if one lot is owned by a trust, and then the lot next door is owned by people who may have an interest in that trust, that those two lots merge for purposes of zoning?
Yes.
Aren't those two separate entities legally? No?
Not according to the courts. The courts have said if they have control of the property, then it's similar to the same as a common ownership.
How is that affected by the people who bought the lot next door and built a house there?
On the lot 127B?
Yeah.
Well, no one has bought that lot. They're trying to sell it.
Well, 127A,
127A is a legal lot because it was sold off
and it's been
prior to the,
fine, but that couldn't be annealed with the next lot next door, even if it was for zoning, would it? If it's owned by two different people?
no. If it's owned by two different people, it's away from that. It doesn't touch that. As long as it's owned, because it was sold off prior to the variance voiding. And 127 was built, 127A was built on. So therefore, it doesn't have to be joined with 127 because the right of that,
Even for
Variance.
zoning?
right. The 127A was, the right of the variance was exercised. And so wasn't B if they had sold it prior to the lapse of the variance.
Who owns lot 127B exactly?
That is into the trust.
Is it in the trust
of
or is
the
it in a
Kirker.
private name?
All-Star?
It's right, the All-Star.
Now, 127B is owned by Robert Kirker, and now it's in his estate,
His estate.
Right, which is.
Thank you, that was
not the trust.
the attorney.
Okay.
Again, I want to just clarify this in my own mind. You're saying that if we have like three house lots or three lots of any kind, and one lot is owned by the John and Mike Trust, and the next lot is owned by John, and the next lot is owned by Mike, that all three lots have to be treated as one for purposes of
If they have
zoning?
control of all three lots,
If who has control?
those three people you were speaking of now, the trust and the other two people, if they're part of that trust, then yes, they have to be combined. But again, remind you, in that case, the only thing you can do is join only three lots. If you had four lots there, you can still only join three according to the law. You couldn't join four.
I'm sorry, you can only join three?
Only three lots can you join together.
Well, you can't join a fourth one?
Even if it didn't create the zoning, give the required zoning, but you can only join three of such lots, not four.
Not four.
Right.
I'm, huh?
Yes.
Okay. Is the owner of Lot 127B, it's in the estate with his daughter controlling that lot, right?
Yes, and she,
Now, she is also part of the All-Star, right?
yes,
But what is her part in the All-Star Trust? Is she just one of many
she
members?
is a 60% owner,
50%?
60%.
60%.
100% owner of both lots, of those lots there, plus 377.
I'm
Who's
confused.
the owner of both lots now?
Dorothy,
I'm really confused as to who owns what
Yeah,
right
that's
now.
what I'm trying to get.
she can give you her name.
Pardon me?
Ask, she
Would
is,
you like me to speak?
she's the owner of that.
If you can tell us who owns
My
what,
name
yeah,
is-
would you identify yourself?
My name is Sharon Kirker Rosen, and I am Robert Kirker's daughter, and I am the 100% owner of All Star Trust,
She's the 100% beneficiary. of the
correct?
trust.
And I am also, in his will, he left me 60% of the vacant lot, 127B.
Right, and 359, right?
Now we're shaking our head here.
Can I make a stab at
Your
getting
name,
right?
please.
Oh, my name's Thomas Crotty. I'm the personal representative of the estate.
Go ahead.
Sharon owns 999 out of 1,000 shares of the All-Star Trust. As a matter of the records of the
We'll
All-Star
give her the other
Trust.
share and say she owns 100% of that
There's
trust.
one share out
Okay.
there of 1,000 floating out there.
Go ahead.
The property that we're talking about was owned by Robert Kirker. It's now in his estate. Sharon doesn't own 60% of that land. She's a 60% beneficiary of the estate.
Of the estate, okay.
Correct.
She doesn't own an interest in the
All right,
land.
right.
Only the estate owns the land.
That's
There are
correct.
two other heirs in the estate besides Sharon. The estate owns the land. She owns the shares of the All-Star Trust, which owns the adjoining smaller lot.
Okay. Who are the two other heirs?
Her two brothers.
Two brothers.
Right, Sharon?
Correct.
Were
Yeah.
those two
Yeah.
brothers involved in any ownership interests in 127 or the other lot?
The All-Star Trust? No, they've never been involved in any ownership of any of this, except in their status as beneficiaries of the estate.
So there's 40% ownership?
Well, there's no control, so it's not ownership. They don't control the land. The land is controlled by the estate, and the estate is separate from the heirs.
Who owns the estate? Sharon?
No, the court doesn't control the
Yeah,
estate.
And nobody
it hasn't
owns the
been-
estate right
It
now.
hasn't been probated yet.
But she has 60% of the estate, right?
At some point, when the estate is resolved and liquidated, she will get a 60% benefit, she gets a 60% distribution of the estate. Not of the land, of the distribution of the estate as a whole.
Right.
All right.
Now going,
Further,
yes, now going back, this land has been owned, and while Robert Kirker was living, okay, he owned that property, 127B, and he was also the trust, All-Star Trust. So both those properties were under Robert Kirker after the variance had voided.
Was he the sole beneficiary under the All-Star Trust?
I believe he was. And so therefore, this board granted the variance, and that variance lapsed after they sold that one property, 127A. 127B was still in that lot, and that variance for that lot lapsed, and because mainly that he owned the property beside it, and those two pieces of property actually joined for the purpose of zoning. So therefore, even though he has passed, those two lots have actually joined for the purposes of zoning, long ago.
even though one is owned by someone else now.
Yes, even though it's owned by someone else now, when it lapsed during the variance, when he was alive, where he owned both those pieces of property, those two pieces of property joined together.
But with those two properties before he died, in separate names or in one name?
A trust and Robert Kirker.
Okay, so two, it was the trust and Robert Kirk.
Right, and Robert Kirker was that trust. So therefore, those two pieces have joined before, and therefore, they still remain joined today.
I'm still a little bit puzzled by how we go from having one piece of land owned by a legal entity, that being a trust, and another piece of land being owned by an individual, a different legal entity. We have two totally separate legal entities, yet somehow or other, it's determined to be a common ownership because the same people are involved in the two entities?
Under the control of one individual.
How about if one lot is owned by a corporation and the lot next door is owned by an individual in the same family? Do we have merger there also?
Yes, if he owns it, if he is part of that
I don't know.
corporation.
Do you know of any authority? I don't know of any authority, any case law for that.
There are cases on that. I didn't find them, but there are
Okay.
cases on that, whereas if you have control of the properties, it is similar to being a common ownership. And therefore, those pieces, for purpose of zoning only, have to be joined together.
Mr. Machado, I'm going to give you the privilege of coming back and speaking with us, but I want to hear what the other people have to say. Please come forward, next one.
I'm Paula Deegan, 308 South Street East. I personally am against any more changes to South Street. If you haven't seen our newest edition, there's talk of more buildings going up at the temple. They need parking for 10,000 cars. Any other changes to zoning over there are going to... we're already overwhelmed with the temple as it is. And that's really all I have to say. I don't want to see anything else change over there.
Thank you very much for your
Thanks.
comment. Next.
Good evening. My name is Katie Glover, and I'm Sharon Rosen's daughter, Robert Kirker's granddaughter. And hopefully, this wasn't in my notes, but I'll try to shed light for you on the issue with All-Star Trust versus Robert H. Kirker estate. My grandfather owned All-Star Trust with Lou Perry, and they also owned Kirker Perry Construction together before it was sold. And they decided to start All-Star Trust as a trust to keep property in. And that trust was Lot 127, Lot 126, and Lot 125. So it goes all the way to the corner of South Street and Hill Street, among a large amount of other properties. Lou Perry, I want to say the late 80s, was not interested in being a part of All-Star Trust anymore. So he stepped aside, and my grandmother, who has also passed, Dorothy Kirker, became a co-trustee, so there were two trustees. In 1994, my mom became a third trustee. So it was three trustees to All-Star Trust. It was my grandfather, my grandmother, and my mom. But I don't know who knows my grandfather here, but he had control. It was 1/3, 1/3, 1/3. However, my grandfather had control of what they did. In 1995, I believe he was trying to do a deal, and it is recorded with the Registry of Deeds. He signed the land over to his personal estate by himself, without the other two trustees. He only needed one other trustee to do it. In 2001, he was trying to sell a chunk of Lot 127, which is now Alpha and Bravo. When he realized that he couldn't sign it over by himself, unbeknownst to my mother, he went and had my grandmother sign it off. So he controlled taking All-Star Trust, that chunk of All-Star Trust, and putting it into his personal estate. At that point, a mistake was made by the board, no offense, but a variance was given even though he had control over both properties. Lot 127A was sold, however, he did not want to build on Lot 127B. And I know a key part that Mr. Crotty pointed out in the letter rebutting the disapproval of the variance, he stated that intent is a key to whether or not the variance should go through. My grandfather had no intents of building on that land. He had a sewer variance done on Lot 126, on Lot 125, never on Lot 127B. He knew he wasn't going to build on it. The person who notarized the deed is Bob Viner, who's right here. It's his best friend. He knows he has no intent of ever building on the land. So if intent is a key to whether or not this property should be given a variance, then there was no intent ever to build on that property. My grandfather died in April of 2012. And at that point, it's still in contention, but either 999 shares or 1,000 shares of All Star Trust then went to my mom. And then in the estate, there's 60% also went to my mom. At this time, if this variance is given, it's going to cause a serious personal hardship to my entire family. Financially, emotionally, my mom grew up there, and this is our family. And just please don't give the variance. And unless you have any questions, that's all I have to say.
Why would it cause a serious personal hardship?
At this point, my grandfather's estate is just under $1 million. This will bump it, the estate in April 2012, to over $1 million. So pretty much the value of the land is going to go to estate taxes.
So it's a monetary thing.
It's gonna, yes. And the other thing is that my mom has owned that we've had that property for a while, just has a lot of memories. So it's two the situations.
Are you saying that that'll cause the estate to lose the exemption it would otherwise have and create tax liabilities?
I'm sorry, can you just repeat that?
Are you saying that the estate would lose its exemption by going over the $1 million mark and?
The estate would lose its exemption, yes. It would go over $1 million.
Okay. Thank you.
Thank you.
Good evening. My name is Robert J. Viner. I'm a tax accountant and a real estate broker. My office in Taunton. Mr. Kirker and I were friends for over 50 years. I was his tax consultant the better part of that 50 years. I notarized the deed. The reason that he wanted that property put in his name and then split back again was so that he could sell. He had somebody that wanted to pay $200,000 for a lot. So he decided to take that piece, have it split off, and sell it, which he did. The other acreage, the three and a half acres, whatever it is, of the what is it, 127B, I guess you're saying, he never wanted to sell that. In the 10 years since he put it back in play, he said I had 6, 7, 8 people come to want to buy that property as a friend, being his friend for all those years. And Bob always said, he said, I never wanted to sell the property, just the one house lot. He said it doesn't make any sense with the property going back, going to somewhere else where it abuts my property. So he then started to use it as a landfill, put stones, things from his property over there. But he had never, ever wanted to sell the property because we had some good offers.
Tell me.
Yes, sir.
In Art 1, we gave him a variance on their property,
Yes, sir.
so it made two properties that were buildable.
Yes, at that point, yes, sir.
Why did he ask for 2 lots to be verified as buildable lots at that time?
That part I cannot answer. I don't even know if he really realized what he was doing at that point. The only one lot that he really wanted was that one lot that he sold, because he had a very,
And you were
very
his
handsome
accountant.
offer. Huh?
You were his accountant, he probably
I was his
relied on
accountant
you for
and-
advice, and
And
you don't know what the reason was.
I don't, it could have very easily been when he came before the board. I didn't come before the board in that particular instance. And when he came before the board, it might have been construed that way and handled that way. I can't verify that. I know he never intended to use it for anything, never intended to build on it. And as far as, because I came with $200,000 offers for that piece of land, and he never wanted to sell it.
Yes.
When that was, you got the variance in 01 on that.
Yep.
Was, Lou Perry was, Kirka Perry owned that land, or was it Kirka?
Kirker, Mr. Kirker. owned
So
the
when
land.
did,
No, I believe the Kirker, that it was in the trust, and then Mr. Kirker had transferred it to himself and his wife at the time. Well, had his wife sign off on it, and he put it in his own name so he could sell the house
so
lot.
it wasn't part of the Kirka Perry at that time, it was,
It was definitely Mr. Bob Kirker himself. Bob Kirker had full control of both All-Star Trust and Robert Kirker. He was the original Swamp Yankee, and nobody told him anything to what to do.
Did he have an attorney at that time?
Did he have an attorney? Yes, I would say he did, sir.
And he relied upon that attorney as well as you?
Yes, I believe he did.
but Lou Perry at that time had nothing to do with this whatsoever.
No, sir. No, sir, he did not.
I see what Dennis is saying.
Did you give anyone any tax advice with respect to the estate or anything like that, sir?
Did I do, what, sir? I'm sorry.
Never mind. Let me ask you this way. You heard what this young lady said about the exemption being lost if it's on.
I guess I can say it better than most here because I'm involved in this thing to some degree. Mr. Kirker spent a great deal of time and money to set up his estate so that it would be going A, B, C, D without a hitch. He hired attorneys to handle the whole thing, had all the different elements put in place. One of the family members has got a dream that the state is worth some $7 million, so he turned around and then sued the estate. And in suing the state, it's cost the Sharon and her husband the better part of $100,000 in legal fees already, just in legal fees, and they haven't even got to square one yet. And Mr. Karate, whatever his name is, I'm sorry, sir, I misspelled your name. He is also going to be looking for in the neighborhood of $25,000 to $40,000 out of the estate as well. They're using the house lot so that the lawyers make sure they can get their money. No, you got that right. I mean, it's fair, sir. I mean, as an accountant, I can't do that. So, why would? Although I do realize that I had a lawyer once tell me, both of you will probably agree, that when you have a lawyer's license, it's like a license to steal. So, that being the case, and I know that's not an insult, it was a joke, sir.
That as a license to print money,
Well, fine. Thank you.
Do you mind if I address
Would
some
you
of
like
these
to
things?
reiterate
What's that?
some of what you said or clarify
I want to
some of
respond to
this?
some of the stuff that's been said here. First of all,
What's that, about your fees, or?
pardon?
About your fee?
My fees, I wish I was making that much in the Okay, so first of all, the estate is pretty much totally irrelevant to this, except that people have brought it in and they're trying to say, oh, it's got something to do with taxes and so on. Well, the estate is several $1 million, and our accountant has estimated that the estate tax is somewhere in the range of $45,000 to $50,000, which right now the estate does not have in cash because it's tied up in real estate and much of the property that's already been given to heirs. This won't bump the estate over some tax threshold. It's already over the tax threshold. One of the things we need is cash to pay the taxes. That's one of the reasons for pursuing, trying to get this to be determined to be a buildable lot. That's one of the motivations. Otherwise, we might say, who cares, let it go. But the fact is, the estate is cash poor, does owe taxes to the government, and can't pay it right now. So we're going to have to get it from somewhere. If these, again, I think the issue of whether the lot, that the small lot with the mobile home, the question of whether that is owned or was owned jointly by the same, in common with the same owner as 127B. If it was in the past, and it may have been, it certainly isn't now, because actually I'm here representing the estate that owns 127, trying to make it a buildable lot, and Sharon, who controls the All-Star Trust, is trying to make it not a buildable lot, so it's pretty clear we're not in collusion here. We're certainly not in collusion. She's working against me. I'm trying to make it a buildable lot, I think, as a matter of... Pardon?
Why?
Why what?
Why are you not in
Because she
accord
owns,
with her?
she owns the small lot next door.
Mhm.
And if this is not a buildable lot, what she's just inherited, or what she's got next to her, is 2.5 acres of unbuildable land, a park. Who wouldn't want that to happen? Who wouldn't want their house lot to be, boom, expanded by 2.5 acres, or whatever she uses that mobile home for? All of a sudden, that lot next to her is worthless, except maybe to her, and she picks it up for a few $1,000. Good deal, huh? We're not in collusion, let me tell you. Here's the thing. With all this business about Bob Kirker didn't really want to subdivide, didn't really want to get this to be a buildable lot, that he didn't care about it, he only wanted to sell off one lot. Well, take a look at tab 4, the plan of these two lots. You got almost a 4-acre lot. This is before the variance. You got almost a 4-acre lot. It needs 150 feet of frontage to sell off Lot A, 127A, as a buildable lot. That's 1 acre, 150 feet. He had it. He didn't have to come to you guys. All he had to go was a planning board and do a Form A. Easy as pie. Just do a Form A. If he wasn't going to sell 127B, what's he doing fooling around with variances? Of course that's why he got the variance. He wanted 2 buildable lots. Limit the cut down the frontage on each lot. That's the whole purpose of this variance. You could have done it as a Form A if you didn't want to build on it. You just carve out the buildable lot with 150 feet of frontage. You designate the extra lot as not buildable. Put it right in the plan. Form A, approved, we're done. He didn't do it. Why? He wanted 2 buildable lots.
Excuse me, I'm sorry.
Sure. All this stuff in hindsight, or rewriting history and saying he never wanted to build a lot, that's just Sharon, I think, saying basically, make this unbuildable. I want to pick it up for dirt cheap. That's my take on it. But all of that really doesn't matter, because here's the point. If you look at maybe look at those plans again. You got 127A, and Mr. Machado concedes that was a buildable lot. It was built on. 127B, which he's saying is not a buildable lot. But if 127B had been built on instead, then 127A would stay buildable. It would be a buildable lot. So here's the point. This talk about merging with the lot next to you. The only time you have to merge lots is if you have one lot, another lot, one of the lots is not buildable, then you merge it so you don't violate the zoning bylaw. But if you have a buildable lot, you don't have to merge it with anything. And that's the point. The first question here is 127B still a buildable lot? If it is a buildable lot, you don't have to merge it with anything. It doesn't matter what you own next door. You don't have to merge it because it's buildable.
We considered that a buildable lot in 2001, did we not?
Right, and it stayed a buildable lot through the end of 2002. And the only thing that Mr. Kirker had to do to keep it as a buildable lot was to sell off one of those two, 127A or 127B. Sell one of them, and according to the case law, it stays a buildable lot. And if it stays a buildable lot, he can own the one next door, he can own a mile down the road, he can own the next mile of land. He doesn't have to merge it because it's buildable. It's still a buildable lot. That's the issue. Is it still a buildable lot? And if it's still a buildable lot, you don't get to the question of merger. You don't take merger and trump buildability with it. You don't make somebody merge a buildable lot, only an unbuildable one. So if this is buildable,
I think we get your point.
no merger.
You've spoken very well.
Okay.
Sir?
There was a little misrepresentation of that statement that he made regarding the necessity of selling off this as a house lot to pay the debt. There is a piece of property that's in Florida that will more than pay for the taxes. This thing still reverts back to attorney's fees, no matter how you cut the cake. The property is free and clear in Florida, will more than pay the government for any taxes owed and have money left over. So far, the attorneys are the only ones that have had a good time with this. So I don't want to make it clear that you don't need to make the variance good simply because they need to pay off the government. It's not true. There are other assets, but there are not enough to pay the legal fees too.
Will that house in Florida pay his legal fees too?
Huh?
Will that house in Florida pay his legal fees too?
Now, was this at one time all one piece of property?
Yes, there was.
Because I noticed there's a barn there. Was this all part of a Kirker farm?
Yes, it was. We've been a family for, I don't know, Sharon?
Back in the 72 or so,
Yeah.
or earlier.
So it was all one piece of property then?
Yes, yes. In fact, it used to be Kirker Fair, that barn you're talking about, and used to be the storage area for Kirker
Kirker
Fair
Construction.
Construction for their equipment and also their materials and so forth. Yeah, that's right, sir.
All right. Thank you, sir.
Okay, thank you.
Does anyone else have something to say? Yes, lady, I couldn't see you behind the...
Sorry, I'm so short. Hi, my name is Melinda Castle. I'm here with my husband, Richard Castle. And we
One with
actually...
a hat on.
Yes.
Usually I don't have hats on here.
Yeah.
Take it off.
Thank you.
You get to see all this gray hair. We're actually the owners of Lot 127A. Yes, and,
Do you enjoy it?
yes, we do. We enjoy it very much.
You have a very nice house there.
Thank you. We like our house. We like that the lot is unbuildable next door to us. Mr. Kirker talked to us about the lot next door. He said that he really didn't have any intention in the future of building on this lot. He said there was a road that goes down the line of our properties between those two lots, but it was more or less like a paper road. There's no physical road there. But I don't have any interest. I don't know his daughter. I'm here on my own behalf. I'm interested on whether the lot gets to be a buildable lot to be sold, and then have the monks build it and put a parking lot there. That I don't want. I don't want a parking lot next door to me. You know, I really don't. I like it the way it is. If anything, if later on down the road they decide to build a house, that's fine. But at this point in time, I'm not looking for the lot to go up for sale to pay for somebody else's legal fees so the monks can buy and put a parking lot there.
Is there a lot of activity there? A lot of traffic coming in?
Not right at the moment. There is some activities when, when they have people there. But once they get the facility geared up, I'm sure they'll have a lot of people there, especially when they have their big holidays. And they have enough land down back that they can put a parking lot. Yes, they do.
Down by the river?
Yes. So there's no reason why. That's my only concern is I don't want this to end up being somebody's parking lot or a business where there's a lot of trucks coming in back and forth or something like that. That's my concern.
Thank you very much.
Okay? All right, thank you.
Thank you. Yes, sir. Return to your...
I'm not going to belabor it, but there is one point that I want to bring up. If you own two lots together, and I'm going to go back to these two lots, 127B and the mobile home, they are joined together. Yes, 127B was with a variance. It was not acted upon. And once you've owned that for a number of years, or even beyond the lapse of that variance, I believe I gave the board copies of that single lot exemption, where if you have two such lots joining each other and they don't meet zoning, then for the purposes of zoning, they have to be joined together. Otherwise, they are not legal lots for purposes of zoning to build upon. And that is right in the zoning, and there are history of that where they join together, and I believe the issue that I brought up, you can only join 3 of such lots. You can't join more than 3. That's in that also. So that is a fact, and I'm sure the attorney knows that. He's smarter than I am, guaranteed there. So he knows that is that issue for that zoning, and those lots, those 2 lots were held together for over 10 years. And once you do that, a variance doesn't go forever. Doesn't go for 10, 20 years and then say, oh, I got a variance, and now just because I've owned that land beside it, I don't need to join it. Yes, you do. You've held them together, and you have to join them for the purpose of zoning, even though they remain as separate lots, but you have to join them together for purposes of zoning. That's all I have to say.
Thank you. Yeah, the conclusion,
I mean, just one point. First of all, the realtor actually did ask the Buddhist temple if they were interested, and they said no. So that might,
and again,
a little bit, they weren't interested.
Mr. Crotty.
Sorry. And then the other thing is, I just reiterate, this is purely a legal question. I really encourage you, if they have any doubts that I'm correct on this, please send it to your town council to look at, because it's purely a question of law. There's been a lot of discussion about a lot of facts that are irrelevant to the question of law that's presented here. I think this is clearly covered by the case law, and, you know, if you don't accept my version of the case law, Mr. Machado has a different version of it, I think you ought to send it to town council to look at. It's not a discretionary judgment call kind of thing. It's purely a question of law. Thanks.
Thank you. Anyone else have any comment? Hearing none, I'll close the hearing.
I don't know.
You what?
You want to close the hearing yet? I want to talk about sending this to town council, because
You want to send what?
I want to talk about sending this to town council because it makes sense, and leave the meeting
You
open.
want to do that? Or
Yes.
do you want to do it during the closure time?
Okay,
Okay?
all right.
That's the best thing to do.
The board is ready to speak on the petition within themselves. And go into executive session. All may remain while the board deliberates, but none may speak. Yes.
Yeah, I'll tell you, I think Mr. Crotty's suggestion was a good one. I think we've got, there are maybe 3 or 4 issues that need to be addressed here. They are legal issues, they're really not factual issues, okay? I have, Mr. Crotty makes a couple of good points. What little I've read from the excerpts of the cases actually makes sense, but it leaves some other questions. The issue of merger, I'd like to hear something from town council on that, because I'm not ready to reach a conclusion on that. On the issue of the common ownership, I really want some input from town council on that, because I'm not quite sure whether common ownership applies or not. If it does, terrific. I have some problems with the concept of 2 different legal entities being forced into a common ownership for zoning purposes, but again, I haven't run across that before. I'm not familiar with any.
Seems odd.
I'm not familiar with any precedent for that, but if there is, then by all means, we should know about it. So on at least those 3 issues, the issue of common ownership, the issue of reliance on the variance, and the issue of the identity of ownership, I'd like to hear something from town council on that, and I'd like town council to review the letter submitted by Mr. Crotty and comment on the legal conclusions that he draws. And I really don't think it makes sense otherwise.
I would agree with Carl. My concern is, if it's a buildable lot, I think the abutters would like to see a house there rather than it be one large parcel, because you're going to see something develop
Untoward.
Huh?
Untoward.
Onward. And I think Dennis had a good point, and I understand what he's saying, but I understand also what legal counsel for the Kirkers are. And I think the best one to try to straighten this out would be town council, and good luck.
I agree with you. So,
I'll tell you, this is a tough room on legal fees.
But they're right.
Brian, so there'll be a continuation on this.
I would suggest we continue this for several weeks or 2 or 3 weeks.
Several weeks, and
send it over to town council for an
then
opinion.
be notified when it's ready from
Right.
town council.
Right.
Do you want to set
Yes.
a date of April 2nd, or do you want to wait?
Well, let's wait, because
back.
I don't know with the alacrity of town council.
Well, we're going to have to re-notify. Okay, we'll have to re-notify everybody.
Well, do you want to set a definite date, and if it's not ready, we can continue it again, or would you rather
So-
re-notify?
Set a date.
Yeah.
Hold on one second, please.
At least a month.
Huh?
Oh, yeah.
I would give
She
it
says
30
the
days
town
anyhow.
council's a little slow.
Yeah.
Yeah.
How far out can you go with setting a date?
I don't know. I'm really not
I
sure.
don't think there's any restriction.
I don't think you'll hear from town council for 2 months.
You want to try for April 16th?
Yeah, try that
That's
on
a little over a month. from
Try
now.
it on April 16th and see what transpires between now and then.
Okay, we'll set it for April 16th.
And let us know, and let all concerned know what's happening.
Okay, so we're going to schedule for April 16th,
Yeah.
and if we have to, we'll cancel.
Fine. Vote for that, April 16th? April
Yes.
16th, April 16th. All right, there's a continuation of this hearing until April 16th. It's going to be presented to the town council for his review and remarks. Thank you all for coming, and we'll see you again on April 16th, I hope.